Well, ladies and gentlemen, it is time once again to look at the stupid parts of the world. I prefer making videos about games and playing video games with the occasional movie review. But after a long day at work, I flip open my newsfeed and find this little shit burger from Newsweek. Court rules Second Amendment doesn't protect AR-15 and assault rifle and large capacity magazines. And it's bullshit. This little video right here is all about how guns are bad because women and children get killed, ignoring the fact that the vast majority of them are killed with handguns and not AR-15s or assault rifles, which is a bullshit term to begin with, but with pistols, like the M9 that I have sitting in my closet right now. But we'll get to that in a minute. So, earlier today, a federal court, that would be the federal court in Massachusetts, ruled that the AR-15 style rifles, high-powered rifles used in the Parkland mass shooting, as well as similar military-style rifles and high-capacity magazines, are not protected under the Second Amendment. Ah, dear fucking Lord, the stupidity of that statement is mind-boggling. And it goes on to say that AR-15s, large-capacity magazines, are most useful in military service, and they are beyond the scope of the Second Amendment and may be banned. And this comes from Massachusetts Federal District Court Judge William Young. Well, Billy, I got bad news for you, sweetheart. You're a fucking idiot. And the case was first brought in January 2017 by several gun owners, the nonprofit group Gun Owners Action League, and gun stores On Target Training and Overwatch Outpost. And the entire reason this came up is because the Massachusetts Attorney General, Maura Healey, put gun dealers and manufacturers on notice that her office would be enforcing the state's 1998 assault weapons ban that prohibits copies or duplicates of the AR-15 and AK-47 rifles. But here's the thing. They're semi-automatic. They're not automatic rifles. And the issue was noticed after the Pulse nightclub shooting in Florida. So because something happened in a different state, she put the people in her state on notice, which is always good. Where a gunman armed with a military-style rifle, and I love the way they phrase that, military-style rifle. Well, a military rifle is select fire. Semi-automatic, bang, 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 one trigger, one bullet, burst fire, which no one I actually served with in the military ever used, and full auto, which was used for suppression, but it's a waste of ammo and it's a pain in the ass to control. Military-style rifle killed 49 people, the second deadliest mass shooting in modern American history. And you know what the third deadliest shooting in American history is? That would be the Virginia Tech College shooting, where a guy killed 32 people with fucking handguns. But she declared that her office would not be intimidated by the gun lobby. Well, they don't really intimidate anybody. But yeah, these are a variety of semi-automatic rifles that fire the .223 caliber round, which is the civilian version of the .556. It's a hunting rifle. You can do a lot of fun things with it, but it's good for hunting. It's good for target shooting. The thing is, it's only good for hunting small game like deer. It's basically a glorified fucking squirrel gun. You can't use it on moose. You can't use it on elk. And God forbid you're in, say, like, I don't know, southern Texas and trying to hunt wild boar. If you're lucky, you'll only need stitches after you irritate one of them with these things. But today's decision upholding the assault weapons ban vindicates the right of the people of Massachusetts to protect themselves from these weapons of war and my office's efforts to enforce the law. Strong gun laws save lives. Well, no. I hate to say it. No, it doesn't. We will not be intimidated by the gun lobby in our efforts to end the sale of assault weapons and protect our communities and schools. Families across the country should take this victory to heart. It's not a victory, first of all, because strong gun laws don't keep people safe. You can look at places like Chicago, D.C., New York, which this past month lost their hold on a second. Slight inertia there. And as I was saying, gun control laws don't keep people safe. If you look at some of the cities and states that have the greatest gun control laws, they still have high variety of gun crimes, mostly done with handguns. But more to the point, there's a reason why you see school shootings, church shootings, office buildings, nightclubs. Those are places where people don't have guns and therefore cannot defend themselves. You don't see shootings at, say, I don't know, an NRA convention or at the shooting range or at military bases. Those people have guns. Those people are willing to defend themselves. If you want to shoot a lot of people, you want to go where they cannot return fire, because then you don't get to have your fun. Pure and simple. I mean, hell, here's a great example of that. There was an art convention in Texas, I want to say within the last year or two, that had a drawing of the Prophet Muhammad that they were very proud of, and they advertised to a great degree. And, unsurprisingly, a couple of dickheads that needed 3 throatfuls of phlegm to pronounce their name decided to show up and shoot the place up, and never made it past the parking lot because it's fucking Texas. They went in trying to start a calamity and wound up getting taken out back like Old Yeller. Guns can make people safe. And that's not even excluding the fact that the school shooting before this one had an NRA instructor who actually killed the bad guy with his own rifle. So no, gun control doesn't make you safe. What it does do is take away the rights of honest citizens to defend themselves. And the fact that this keeps getting pushed by the media and the politicians on the left is nothing short of amazing, but not very unsurprising. But it continues. More than 10,000 AR-15 style rifles were sold in Massachusetts in 2015, but since Healy issued her enforcement notice, sales have virtually ended. Yes, because they don't want to go to jail. And see, here's the thing. Honest citizens have said, holy shit, these guns are going to get banned. I don't want to break the law. Criminals, of course, don't give a flying fuck, or else they wouldn't be criminals. But you're only hurting the honest citizen. And the reason I don't like this ruling is because it sets precedent. Which means that, well, this only applies to Massachusetts currently. Because this is a federal ruling. Massachusetts is open to banning AR-15s, and therefore you're going to have to go to a gun buyback program, lose a shit ton of money if you're compensated at all, or face criminal proceedings. Arizona, where I live, is free to say, fuck you, we're not going to do it. But it's not the point. I'm sort of libertarian in this degree where I find any gun control that isn't a citizen with a non-felony record and a clean bill of mental health is allowed to buy whatever they want. If I want to have an M60, and I can afford an M60, and I can afford the couple grand it would take to enjoy it for 30 seconds at the firing range, as someone with no criminal record, no mental health issues, I should be allowed to do that. There's no reason why I can't. I have done nothing wrong. But, to continue. Writing for the majority in the Heller decision, the late Justice Anton Scalia clarified, like most rights, the Second Amendment right is not unlimited. It's not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. Which is really weird for Scalia to say, because he was a bit of a fundamentalist when it came to the Constitution. He was under the belief that the Constitution could not be interpreted by today's morality, but by the morals of the times of the penning of that constitutional amendment. Which, I don't know what's up with this, but I still don't agree with him, though. And it goes on to say that the weapons are most useful in military service. M16 rifles and the like are not protected in the Second Amendment. Why not? Absolutely why not? The AR-15 is not fully automatic. It's not select fire. It's semi-automatic only. And is used for hunting, used for target shooting. Yet the AR-15's present-day population is not constitutionally material. That's true. Just because the gun is popular doesn't mean it should be effective, but it also doesn't mean that it should be taken away either. And it's not most useful in military service. Right now, they're actually making a move towards the M14, which is a different style rifle from the M16. And the M16 is not an AR-15. But the AR-15's analogs, along with large capacity magazines, are simply not weapons within the original meaning of the individual constitutional right to bear arms, which is bullshit, and I can tell you exactly why it is. because at the time of the writing of the Second Amendment, the Army and the Navy, from when they had in the Marines, which were a part of the Army at the time, were armed with muskets. The right to bear arms, as interpreted in the penning of the Second Amendment at the time of its writing, allowed citizens to carry muskets. And it also allowed citizens to own cannon. On more than one occasion, someone who owned a merchant ship that was afraid of piracy, who was not military, was able to buy cannon to put on their ship because it was protected under the Second Amendment of the Constitution. Military weapons of war were the implicit meaning of that Constitution. And just because the guns have gotten better today than they were fucking 200 years ago doesn't change the fact that that's what it was intended. A soldier is issued a musket. A citizen may purchase a musket. In this day and age, a soldier is issued an M16 or an M14, depending on which branch of service you work with and your position within it. The citizen can buy an AR-15. Now, it's not the same rifle. It's close, but it's not the same. But the intent is still the same, that the citizen be allowed to carry the same firearm as the soldier. That was its entire purpose. That's still its entire purpose. And the right to bear arms shall not be infringed, which honestly does not mean that you get to say, oh, by the way, you don't get to have as big a magazine. By the way, you have a waiting period. By the way, we don't like the color of this particular pistol. Thank you very much, fucking California. And therefore, you can't have it. Like I said before, I personally own an M9. It's a Beretta 92S that was adopted by the U.S. military back in the 80s. It might have been a little bit earlier than that. It might have been back in the 70s. But I have not the civilian version, but I own the military version of the Beretta 92S. The M9 is what is classified in the military. I carried one for 6 years when I was in uniform. I own one today. That would technically fall under the amendment to this amendment of a military-style weapon. And it's fucking bullshit. Massachusetts is free to ban these weapons in large-capacity magazines. Other states are equally free to leave them unregulated and available to law-abiding citizens. Americans are not afraid of bumptious, raucous, and robust debate about these matters. We call it democracy. Except, here's the thing. We're a representative republic. We're not actually a democracy. There's a difference, but I would expect a judge to know the difference, but he's already been shown to be a fucking moron, so just leave it at that. And Justice Scalia would be proud. I got to admit, I haven't come across this writing of his, and I'm going to look it up later, and I might actually amend this video at a later date. But here's the thing that kills me here. He's been dead for 2 fucking years. So he can't even speak out against this, which is, I don't like them invoking his name on this. But hey, you know what? District of Columbia versus Heller. Let's take a look at this. Whoop. Let's make this a little bit bigger. Legal Information Institute from Cornell University Law School. See if we can find the fun parts. District of Columbia law bans handgun possession by making it a crime to carry an unregistered firearm or prohibiting the registration of handguns. Provides separately that no person may carry an unlicensed handgun, but authorizes the police chief to issue 1-year licenses and requires residents to keep lawfully owned firearms unloaded and disassembled or bound by a trigger locker similar to vice. Respondent Heller, a D.C. special policeman, applied to register a handgun he wished to keep at home, but the district refused. He filed this suit seeking on Second Amendment grounds to enjoin the city from enforcing the bar of handgun registration, the licensing requirement insofar as it prohibits carrying an unlicensed firearm in the home, and the trigger lock requirement insofar as it prohibits the use of functional firearms in the home. The district court dismissed the suit, but the D.C. court reversed, holding that the Second Amendment protects an individual's right to possess firearms, and the city's total ban on handguns, as well as its requirements that firearms in the home become non-functional, even when necessary for self-defense, violated that right. Okay. So these are the articles that were held in this decision. The Second Amendment protects an individual right to possess firearms unconnected with service in a militia, and to use that arm for traditionally lawful purposes such as self-defense within the home. The amendment's prefatory clause announces a purpose but does not limit or expand the scope of the second part, the operative clause. The clause's text and history demonstrate that it connotes an individual right to keep and bear arms. The prefatory clause comports with the court's interpretation of the operative clause. The militia, comprised of all males physically capable of acting in concert for the common defense. Nowadays, I think we can include women in that. The rifle and the handgun in particular are great equalizers in that regard. The anti-federalists fear that the federal government would disarm the people in order to disable the citizens' militia, enabling a politicized standing army or a select militia to rule. The response was to deny Congress power to abridge the ancient right of individuals to keep and bear arms so that the ideal of a citizens' militia would be preserved. Seems pretty straightforward. To prevent the tyranny of the government, the citizens' rights to own and bear arms shall not be infringed. I don't understand what's so hard about that. And here's the thing. I don't think that the Second Amendment or the Bill of Rights in general is open to interpretation. I guess I'm kind of libertarian in that regard. The court's interpretation is confirmed by an analogous arms-bearing rights in state constitutions that preceded and immediately followed the Second Amendment. The Second Amendment's drafting history, while of dubious interpretive worth, bullshit, reveals that 3 state Second Amendment proposals that unequivocally refer to an individual's rights to bear arms. Interpretation of the Second Amendment by scholars, courts, and legislators from immediately after its ratification to the late 19th century also supports the court's conclusion. Again, I don't know why this needs to even be interpreted. It is very simple, direct language. And moving on. Like most rights, the Second Amendment right is not unlimited. And this is where we have an issue with this. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. For example, concealed weapons prohibitions have been upheld under the amendment or state analogs. The court's opinion should not be taken to cast doubt on long-standing prohibitions or the possession of firearms by felons and the mentally ill, or laws forbidding the carrying of firearms in such places as schools or government buildings, where, I hate to break it to you, a lot of these shootings tend to happen because no one has a fucking gun. Or laws imposing conditions and qualifications on the commercial sale of arms. Miller's holding that the sorts of weapons protected are those in common use at the time find support in the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Well, here's the fun part. In common use at the time. At the drafting of the Second Amendment, the common weapon of the time was the musket. As I've said before, the soldier had it, the citizen had a right to have one and carry one. Today, they have the M16. As citizens, under this in common use at the time, this is an important little phrase to look at right here, means that I have a right to purchase and carry the same weapon. Now, I'm not a big fan of, like I said, the firearms ban. I haven't done anything wrong. I'm not a criminal. I have mentally good health. If I can afford it, I don't see why I can't have it. And there's even grandfather clauses, and you can still apply for a automatic weapons license. It's fucking difficult as hell, and it's very expensive, but you can still have it. So it's even then, it's not completely been outlawed and banned. It's just really fucking hard to do. The handgun ban and the trigger lock requirement as applied to self-defense violate the Second Amendment. The district's total ban on handgun possession in the home amounts to a prohibition on an entire class of arms that Americans overwhelmingly choose for the lawful purpose of self-defense. Now, that would also apply to AR-15 rifles and their like. Under the standards of scrutiny, the court has applied to enumerate constitutional rights. This prohibition, in the place where the importance of the lawful defense of self, family, and property is most acute, would fail constitutional muster. Similarly, the requirement that any lawful firearm in the home be disassembled or bound by trigger lock makes it impossible for citizens to use arms for the core lawful purposes of self-defense, and is hence unconstitutional. Because Heller conceded an oral argument that the D.C. licensing law is permissible if not enforced arbitrarily and capriciously, the court assumes that a license will satisfy his prayer for relief and does not address the licensing requirement. Assuming he's not disqualified from exercising Second Amendment rights, the district must permit Heller to register his handgun and must issue him a license to carry it in his home. And this was by, again, Justice Scalia, delivered the opinion of the court in which Robert C.J. and Kenny Thomas, Alito J.J. joined. Stevens J. filed a dissenting opinion which Stoudard, Ginsburg, and Breyer joined. And Breyer fucking dissented as well, which Stevens, Stoudard, and Ginsburg also joined. But I only disagree with one part of this. The Second Amendment right is not unlimited. I am not against a firearms registration. I'm not against mandatory background checks. Hell, we have them anyway. If I go to a pawn shop or to a gun show or to the gun store here in my town in Arizona, I have to go through a background check. And I'm totally okay with that because they have to determine whether or not you have a felony record or if you have some sort of mental instability that would prohibit you from purchasing a firearm. If the law enforcement in Florida, in Parkland, had actually done their fucking jobs, if the sheriff's department had done their jobs, if the FBI office in Parkland had done their jobs, that little nitwit would not have been able to buy a firearm. He would have been in jail. It's not a failing of gun control that caused the Parkland shooting. It was the failure of those who were supposed to enforce the laws that led to it. But I digress. Again, I don't agree with the interpretation. I have the right to free speech. That means I get to call you a cunt. It means I get to say the word nigger. It does mean that if I say the N-word, I can get my ass kicked. But if I'm willing to take that risk, hey, so be it. It does not allow me to use criminal language like, say, shouting fire in a theater, because that would be a criminal offense because I'm trying to cause panic. I'm trying to cause harm. Buying a handgun, buying an AR-15 should not be an issue. Using the weapon illegally is where that limitation comes in. Even if I'm walking down the street waving it around and shooting it into the air or shooting frickin', trees and shit in my neighborhood, I'll go to jail and I will lose my right to forever own a firearm. In the same way that shouting fire in a crowded theater is a violation of the law. It's fucking ridiculous. And the thing I don't like about this, like I said, is it's about precedence. And I don't like the fact that this is open to interpretation. And the reason I bring up the precedence is because a federal court judge has ruled that these weapons are not covered under the Second Amendment. California can now ban them. Arizona could, but they won't because Arizona has some of the best gun laws in the country, in my opinion. But Utah, Nevada, Florida, D.C., Chicago can now again want to start banning fucking firearms. And I'll tell you what I'm going to do. I'm going to go buy an AR-15. I've wanted one for years, and I'm finally in a position where I can own one. I have the money for it, but this is bullshit. This entire thing is bullshit. And I think everybody should be writing letters. Write your congressman, write your senators. Hell, write the fucking president. Write the Supreme Court. This cannot be allowed to stand. It needs to be struck down. This ruling needs to be struck down. It needs to be rendered inoperable. And we need to get on with our fucking day and start looking at the things that really matter. Because gun control, like I said, does not make you safe. All it allows is for the opportunity for you to be a victim. And if you honestly believe that you want to feel that way, that's on you. But me personally, I'm not a big fan of the government saying, oh, you can't handle this weapon. You can't own it because it looks scary. Anyway, thank you very much. I'll see you guys next time.